The U.S. Supreme Court issued one of the biggest product liability decisions in years, and it really could affect the landscape in Roundup cases. Let me give you a little background on that case. So Monsanto, a big company in Missouri, created a product called Roundup. It includes pesticides, other seed products, etc. And part of that product, it is alleged, had caused non-Hodgkin's lymphoma in a number of different people. So there was a number of lawsuits filed against Monsanto, which is owned by Bayer aspirin people in Germany. Bayer purchased Monsanto. So the cases are against Monsanto, but it's basically Bayer that's behind them. Monsanto defended these cases, and there was a number of verdicts against Monsanto holding them liable for their Roundup product causing non-Hodgkin's lymphoma or cancer to folks. And so these big verdicts happened throughout the country. Monsanto also won some verdicts and got defense verdicts in a number of them. Well, there's also a class action settlement that happened with Monsanto or Bayer and victims, which is presently pending, and you can look on the internet for that. But let me kind of give you some background or some inside baseball on what exactly Monsanto did to defend these cases. They argued that any cases for failure to warn that their product is dangerous and caused cancer were what they call preempted, which means that there's a federal statute that requires Monsanto to issue a specific warning, and for states to contend that they should have issued a separate warning or a different warning or one that's different than the federal mandate was what they call preempted. See, in the U.S., we have a supremacy clause, and what that means is that federal laws that conflict with state laws, typically the federal law will be supreme to the state court law. Just like a U.S. Supreme Court opinion on a subject becomes the law of the land if it conflicts with a state court opinion on precisely the same issue. So in this case, the U.S. EPA had issued a warning that Roundup had to put on each product, which had specific language of what exactly they were supposed to put on each bag of Roundup, and it said a specific lines, specific language, etc. And the U.S. Supreme Court ruled last week that Monsanto and Bayer could not be sued for failure to warn that its product caused cancer because the U.S. EPA already told them what specific warnings to put on their packages. It's a big win for Monsanto. Does that mean that these cases will go away? No. There's still product liability claims against Monsanto as a result of the product. It'll just be a different litigation. That'll be an arrow that'll be out of the quiver of plaintiffs to allege that they failed to warn when they knew that their product caused cancer. If you look throughout the world, other places have different ideas as to what Roundup, whether it causes cancer or not, whether it's allowed to be sold, what type of warnings, etc. But this is for the U.S. In the U.S., the U.S. Supreme Court has said the law of the land is that you will not be able to sue Monsanto for failure to warn because that is preempted by federal law, which says they have to put a specific warning on their products, and they've already done that. The ruling changes the legal landscape of these cases, but the Supreme Court did not address whether or not the product causes cancer. That's for others to decide, or whether or not there'll be evolution in this area. But it is clear that plaintiffs will lose the ability in a failure to warn case to win a case against Monsanto.